Let me just first start out that um, certainly, and I'll start with what Miss Apple's comment was that certainly through the use of social media or messaging of various types, one can warn somebody of, I guess, maybe bad service, something that um, occurs at a business. May not be the best way to do it, but fine. That's the way our society is. And some of that, quite frankly, is protected speech. It- the protections on that speech, however,
All right, guys, welcome to today's video. What starts as a simple conversation about social media complaints quickly turns into something much bigger. The judge calmly explains that while people can criticize businesses online, even harshly, there are limits. Protected speech exists, but only up to a point. And as this case unfolds, it becomes clear that someone may have crossed that invisible legal line.
are in some ways limited. You can't threaten people. Now, you also have to realize within the context of this that the cat is brought in 40 minutes later, 45 minutes later, whatever it is, the cat is released at the owner's request. After that, I guess one could complain about that service, and that's fine. One could say, that's fine. Some of it regarding the murdering of animals.
The judge shifts focus to the timeline involving the cat being brought in and later released at the owner's request. He notes that dissatisfaction with service could justify complaints. However, when accusations escalate into claims of animal murder, the tone changes. As an observer, you can sense a court separating emotional outrage from legally dangerous language that may carry serious consequences.
Likely is going to result in a lawsuit or could um, because it overreaches. But I'm not here to decide First Amendment libel slander issues or defamation. I'm not here to decide that. Um, at some point, however, the posting of these messages leads to these other contexts. I think defense is wrong. I think it exactly fits within the statute. I also think that certainly at trial, one may be able to argue one's intent. Um, I think, however, that whether one's upset doesn't really matter. If you're upset or whatever, when you start threatening physical harm through the use of some type of incendiary device, that raises this to a whole other level.
The courtroom atmosphere tightens as the judge addresses the heart of the issue: threats. He makes it clear that being upset doesn't justify language suggesting physical harm, especially references to an incendiary device. From the bench, he questions intent, asking why such specific words were used. In that moment, the discussion shifts from online frustration to potential criminal conduct.
I think it becomes further a problem given, as I was indicating on the record and asking questions about, the sort of access that individuals may have to the business. It is fine afterwards to say, well, that's not what I intended. That's not what you intended. Why'd you say that? Why'd you say those particular things? I think that what's been testified to fits exactly into the statute that Ms. Apple defines, would find that the people have indeed sustained their burden of showing this offense of the unlawful posting of a message, and would bind the defendant over to stand trial on that charge. I'm not adding charges, which I think, given the testimony, I certainly could. And I could certainly add more serious charges because of the defendant's conduct, but I will not. I'm going to decline to do that at this point.
The judge concludes that the evidence fits the statute and formally binds the defendant over for trial on unlawful posting charges. Notably, he states he could pursue even more serious charges based on the conduct, but chooses not to at this time. It's a measured yet firm decision, leaving the case to move forward in court. Like the video, subscribe to the channel, and we'll see you in the next video.